Hello, my name is Sully Sullivan, and I am the Executive Director of the Hemp Industry Trade Association of Arizona, and I spell my name Sully, Sullivan. Thank you for coming out today. The Hemp Industry Trade Association's mission is to grow, sustain, and protect Arizona's hemp industry and those that find benefit from it. We have filed a lawsuit against the Attorney General's office to protect the federally legal hemp industry in the state of Arizona. Our lawsuit is trying to protect not only the hemp industry, which is composed of farmers, distributors, manufacturers, and retailers, but more importantly, to try to protect the people of Arizona so that they can continue to have safe access to federally legal hemp. First, we are going to bring up Tom Dean, an attorney from our law firm, Full Spectrum Law Collective. Tom Dean will explain what the next steps are on our ongoing lawsuit with the Attorney General's office. Thank you.
Thank you all for being here. And thank you to HITA, the Hemp Industry Trade Association, who's done so much to assist in organizing the resistance to the Attorney General's office efforts to destroy the retail hemp market in the state of Arizona through what we believe to be an illegal interpretation of the law. Before I get started talking more about that, I'd like to thank the hemp industry, from growers to retailers. But of course, the Attorney General's threat of enforcement is directed primarily at those who engage in the retail sale of consumable products here in Arizona. And for them, I'd like to give a special thanks for their contribution to Arizona's economy, which on an annual basis, the products that they sell, that the Attorney General's office would like to stop, to declare illegal, and to hand over to the dispensary and marijuana establishment industry, contributed $300 million in wages annually and has generated, I believe, 8,000 jobs, according to Whitney Economics Hemp Overview by their chief economist in January of 2024. So this is a huge part of the economy that the Attorney General's office would like to destroy, as well as all of the lives and jobs and families that go along with it. It's done so well that it's become the envy of the oligarchs over at the marijuana industry, who would like the Attorney General to declare that they're the only ones who are allowed to sell these products. But they sell products that are 10 times or more powerful than any of the products that are sold as hemp products, which are relatively mild in terms of any psychoactive effect. It's sunny out here and it's bright, but inside the chambers of the Attorney General's office, the forces of darkness are hard at work. Hard at work setting up raids, ready for indictments, threats of imprisonment, seizures, and business closures, as they have threatened consistently. In most recently, their enforcement letter that was made public just a month ago. As I speak right now, my partner, John Udell, is in the process of putting the finishing touches on a petition for special action to the Arizona Court of Appeals, where we're asking them to stop the Attorney General's office from any further attempt at enforcing what we again believe to be this unlawful interpretation of Arizona's hemp law. For those of you who have been around for a while, this kind of problem, I would imagine, feels a little bit like deja vu. For those who are newcomers to the cannabis world, welcome to the fight. We've been here before. We've fought the Attorney General's office before, and we have won. And that's exactly what we intend to do again here in this petition for special action that we will be filing with the Court of Appeals imminently. Thank you.
Mohammed, Mohamed, last name Lotfi, Lotfy. I'm the co-founder of Wake Bakery, which is a small business that started probably last year in Tempe, Arizona. And we came here with a concept of opening a business and completely federally legal. And that little dream translated into a small store in Mill Avenue which became like the community's favorite in a very, very short time. That business translated into checks, pay stubs, income for many of our community, parents, single parents, veterans, students, you name it. We've been welcomed into this community, and we've been overwhelmed with how we've been welcomed at Hemp, Arizona. I'm a medical doctor by trade, and I insist on importing the standards of the pharmaceutical standards into the safety of our products, down to the milligram of the content of hemp ingredients. Prohibition is not the answer for safety. Prohibition is not the cure for safety of the community. Regulation is. We're not asking for a shortcut. We're not asking for a loophole. We're asking for a legal solution. And a legal solution for this to protect small business and the community from the monopoly of the cannabis industry. Thank you.
Good morning, and thank you all for being here. My name is Tiffany Hernandez, Tiffany Hernandez, Hernandez. I do own Canna Queens. That's KANNAKWEENS. We actually manufacture a hair serum made strictly with just CBD. It's not psychoactive at all. If anything, it's very therapeutic. We work with cancer patients all over. Canna Queens actually goes out. We advocate. We speak to cancer centers and people who are actually going through chemo, and not just cancer, different medical conditions that people go through. But the simple fact is, the hair serum you can't get in dispensaries. This is something that I've been working on for the past 7 years, and just looking into a storefront actually in Tucson, Arizona, and this really put a halt on that. So it's my livelihood. This is for my children. This is just for everyone out there. It would really hurt us. So thank you all for backing us and being here. HITA, tremendous work. Thank you guys so much for being here.
Thank you very much, Sully, for this time. Please give me one moment to get my notes up. I apologize. Thank you very much, HITA, for this opportunity to speak. I'm coming at this from a little bit of a different perspective. I'm an Arizona native. I've been in the community for many, many years. I'm an Air Force veteran. I'm a former EMT. I'm an advocate for mental and physical health. And I love and respect the law. But more importantly, I respect public safety and what it truly means to keep the public safe. I can tell you without hesitation that the current legal approach to hemp-derived cannabinoids in Arizona, specifically under the opinion of the Attorney General, does not promote public safety in any way, shape, or form. It does not protect our children. It does not target cartels. It does not target violent crime. What it does is it criminalizes Arizona farmers and small businesses who have tried to make their stake in the Arizona cannabis community. I spent over a decade as an Arizona state trooper, patrolling the highways, responding to crises, putting my life on the line for the safety of others in Arizona. I later became a homicide detective, investigating the very worst society has to offer from violent crime to drug-related offenses, and none of those were caused by hemp. I come from a conservative background. I was raised on the narrative that drugs are inherently dangerous. With no questions asked. I drank the Kool-Aid, but no one ever told me the truth about medicinal properties. No one ever told me that the Drug Enforcement Administration itself admits the fact that nobody's ever died from the ingestion of cannabis or hemp products alone. No one ever told me that these are the truths. It's just been hidden from us. Words matter, and there's a lot of them being thrown around in this debate. Sorry. People are calling these products synthetic or dangerous, but the federal government has already addressed this issue with the 2018 Farm Bill. They said if it's hemp-derived, contains less than 0.3% delta-9 THC, it's legal. So what are we arguing about? Let's be honest here. The issue at hand isn't about safety. It's about freedom. The These goods are not marketed towards children. They're sold behind an ID wall at 21 plus establishments to adults who have the right to decide what they want to put in their bodies. Many of these products offer relief to veterans for anxiety, chronic pain, PTSD, insomnia, and for some, it's their only accessible option. Some folks will call this a drug, even though the federal government disagrees. And I've learned from people far smarter than me that it's not the drug itself, it's the relationship to a drug that a person has with it. We cannot legislate morality. Every time we try to create unintended, or every time we do that, we create unintended consequences. If we make these products illegal, we don't eliminate demand in any way, shape, or form. We create a black market in which law-abiding citizens into criminals are. That's not justice. That's a return to the field war on drugs. Perhaps the most concerning is that this opinion strips law enforcement officers of their autonomy. It dictates priorities from the top down, forcing cops to waste time and resources cracking down on hemp, a completely benign substance, while fentanyl, human trafficking, and violent crime continue to plague our communities. I stand for smart, responsible, and safe use of these products, but enforcement of this should not be law enforcement's top priority. The argument will always be that we have to save the children, and of course, we all want that. But these products are already kept behind ID walls. No child is walking in and demanding these products. So I say this as someone who wore the badge, who buried the victims, who knows what real crime is like. This is not it. Let's get our priorities straight. Let's stop wasting taxpayer dollars. Let's regulate, not criminalize. Let's support our farmers, our small businesses, and our veterans of Arizona, and not punish them. Thank you.
Hey, Ray. Thanks for being here. It's true, we probably could have chosen a federal venue to bring this action, but we felt it was better to bring it here in state court. We started at the Superior Court. We're now heading for the Arizona Court of Appeals. And the reason is because this is not just a question of federal law, it's a question of state law. And it's the state law that we believe the Attorney General's office has misinterpreted. And so we're asking state courts to review the state law and to agree with us that she's overstepped here. The other question was,
haven't state voters already sort of weighed in on how they want marijuana and marijuana-like products, if you will, to be regulated?
Yeah, I mean, we've had a couple of initiatives. One was a medical marijuana law. The other one was an adult use law, both by way of voter initiative. But we also have the hemp law, the Arizona Hemp Act, that was enacted by our legislature. And in that law, it clearly says that the plant cannabis sativa L and all parts of that plant are lawful as hemp, provided they do not contain more than 0.3% delta-9 THC. Delta-9 is a cannabinoid, and it's the only cannabinoid that both the federal government and state government have chosen to restrict in any manner. Any other cannabinoid, be it delta-8 or THCA, our legislature and the Congress have specifically declined to restrict in any manner, but that's exactly what the Attorney General's office is attempting to do here by creating a made-up term, intoxicating cannabinoids. That term has no meaning in law or medicine, and this has just been invented by the Attorney General's office in a way to justify this, what I think is abuse of discretion on the part of her office.
Any other questions from the media?
Yeah.
Yes. Good.
You probably stay there. Break it down for me. What exactly is the AG's office doing that you have an issue?
Sure. So the AG's office about a year ago issued what's called an advisory opinion, which said it was specifically addressing a particular cannabinoid called delta-8 THC, which is kind of a cousin of delta-9 THC, the one cannabinoid that is restricted, and arrived at the opinion that these products were unlawful. A year went by and there was really no meaningful enforcement action, with a couple of exceptions on that opinion. And until about a month ago, when a year after that advisory opinion, she issued an enforcement threat letter saying that she was giving everybody a month of grace period, so to speak, who's engaged in the sale of these products, to cease and desist from further sales, because commencing on April 24th, she was going to begin enforcing her novel and, in my opinion, misguided interpretation of Arizona's hemp law. Specifically, she's saying that certainly cannabinoids are a part of the hemp plant and therefore considered industrial hemp, as long as they don't have more than 0.3% delta-9 THC in them. None of them do. If they did, I would agree that they're not lawful. but the products and the retailers that are involved in members of HITA do not sell any such products that would be in more than 0.3% Delta 9. But the Attorney General's office doesn't like the fact that some of these products might have a psychoactive effect. She's chosen to use the term intoxicating. And she would like to enforce that interpretation, although there's really no support for it to be found in either federal or state law. In fact, in our state law, there's a specific provision in ARS 3-312E that says that if federal law is ever more permissive or broad or liberal, so to speak, that the hemp industry here in Arizona should feel free to follow the federal law and operate outside of the parameters of Arizona's hemp program. And that's exactly what Congress did when it made it in 2018 said that parts of the plant does specifically include cannabinoids without limitation. The DEA agrees that, for example, Delta 8 is legal and should be allowed to be sold as hemp. The Ninth Circuit Court of Appeals, which includes Arizona as one of its member states, also agrees that in particular Delta 8 in a case called AK Futures versus Boyd Street is absolutely legal to manufacture and sell throughout the country in states that have signed on to the Farm Bill. So the Attorney General's office here is really standing alone in its unique and I suppose interesting but misinterpreted version of the law. They're wanting to enforce what they wish the law was, but it's not. And that's why we feel confident that when the Court of Appeals is able to look at this, that they're going to agree that the Attorney General's office has overstepped, and they will agree with us that their interpretation is incorrect, and therefore any enforcement of that interpretation would be unlawful and unconstitutional.
How exactly is hemp regulated in comparison to marijuana at a dispensary? Can I walk into any random gas station and get some Delta 8 flower and then on TV? What are the limits?
Yeah, so HITA has been actively working to pass legislation so that there's some more regulation of this area. Right now, for example, we don't have as vigorous testing as is required, for example, in medical marijuana. We want to have that in place. We want to provide greater regulation. But right now, you can walk into Circle K or any other retail outlet and you can purchase cannabinoid products. Many of them are CBD products. It's interesting that although there's zero legal distinction between CBD and Delta 8, for example, as you mentioned, there's no legal distinction, and yet the Attorney General's office has said she's going to treat them entirely differently, based solely on the fact that she doesn't like that the one has any psychoactive effect, and in her opinion, the other does not. Which is also itself incorrect because CBD does have mild psychoactive effects. So there's a line somewhere that she's trying to draw that says, well, but when it's a little bit too psychoactive, then we think it's not that Arizona shouldn't be able to sell or possess or use, which is interesting because they already are. Every Arizonan in Arizona, 21 years or older, is not only allowed to possess and use these products, but they're allowed to manufacture them in their own homes. So there's nothing illegal about the public is already using these 80 products that have cannabinoids in them, making them even themselves at their homes. So these aren't dangerous products. These are entirely legal for people to use. It's just that the Attorney General's office, and that's when you really boil down to what this is all about, stopping the hemp retail market from selling these products and handing it over to the established oligarchy that is the marijuana industry. So only they can sell them. And for the Arizona industry's part, I believe that this is, they feel, a rival industry, that they want a monopoly on these products, and that rather than compete on a free and fair level playing field, they want to have these products folded within their already existing monopoly and to shut down this industry that's been operating now for at least the last 4 or 5 years selling these products. So suddenly there's an emergency. These products have been out there for a long time. So we're not sure what the emergency is, but that's the Attorney General's position.
I mean, could the line she's drawing simply be that there's less rigorous testing and regulation, and if that's the case, how do you ensure that the product is safe if it's less so tested than, say, a cannabis dispensary or a marijuana dispensary?
Well, if that is the case, which I haven't seen her really, I would invite her to join HITA then in helping to support HITA's bill to enact just those types of laws and regulations. Members of HITA have to promise to never sell any of their products, consumable products, to people who are under the age of 21. We think those are the best practices, and the members adhere to those practices. These products are tested. The Department of Agriculture is a regulating agency, and they promulgated regulations. There are specific testing labs that are responsible for testing the hemp products. So there is testing. We think it should be, we want it to be a little bit more rigorous, that's true, but there is testing in place already. And so I would just say, if the Attorney General's office is really concerned about those things, then please join us in passing legislation to effectuate that, rather than focus on destroying an industry, destroying the entire hemp retail industry in Arizona, and handing it over to the oligarchs over at big marijuana.
Any other questions?
Yeah, what are you going to argue in your special action?
Well, the simple argument is the definition of industrial hemp in the state of Arizona is the cannabis sativa L plant and all parts of that plant containing no more than 0.3% delta 9 THC on a dry weight basis. That's the simple answer. It doesn't really need to be much more complicated than that, although the Attorney General's office has tried to make some arguments that do complicate it slightly, but that is, in effect, that's the argument in its simplest form. And we think that that's what the Ninth Circuit said, that parts of the plant, all parts of the plant means all parts of the plant. And that's also what our own Arizona Supreme Court said in a case called State v. Jones, which is a medical marijuana case, but where the Attorney General's office was taking the same position in arguing that medical marijuana could not include these cannabinoid products. The Supreme Court disagreed and said in that statute used very similar language to all parts of the plant, but the Supreme Court of Arizona said, listen, all parts of the plant means all parts of the plant. It's not hard, unless there's some other law that would restrict it otherwise. So we have precedent both in our own state Supreme Court, as well as the Ninth Circuit Court of Appeals, as well as the DEA's interpretation of federal law. And so we feel really confident that our position is the correct one.
Anybody else? Any other members of the press? Any question?
Yeah, I have one more.
Yes.
And although you're the lawyer, I would love to hear from Dr. Lotfi on this as well, because at Wake and Bakery, of course, as you know, they were serving 100 milligram THC ice mochas and other things like that to the public. Correct me if I'm wrong. And so doesn't our state law for hemp says that you can't have anything that's ingestible, or there should be nothing to ingest from the hemp other than seeds. So how do you justify serving people 100 milligram delta 9 THC ice mochas without a dispensary license?
I'll hand this to Dr. Lofty. I'll just make one quick comment. And the reason is because of ARS 3-312E, which says that if the federal law allows for this activity, then state law, the state industry, hemp industry, is allowed to follow those more liberal federal laws and not be bound by the restrictions that were placed initially in Arizona state law. The aspect you're referring to, ingestibles, that is products that pass through the digestive system, and obviously wouldn't include inhalable products like THCA flower or Delta 8 vape pens. It has been superseded by the federal law, and under that 3-312E, Arizona's hemp industry is fully authorized to operate under that broader, more permissive federal law.
Dr. Lockby, I guess you're from
Sure.
from Illinois. So maybe you're not as familiar with Arizona, but we don't always caught in a federal law here.
Well, I'm no lawyer, so whatever I'm going to say is not going to be.
Our marijuana program, of course, is a state law. If we listen to federal law, marijuana would not be legal in Arizona. So what again is your sort of justification for not adhering to the state law on hemp that says you can't ingest the hemp products?
the same law that carved out that in one part. If you scroll down, you're gonna find that the industrial hemp, includes, all the products, ingestible or non-ingestible. And by the way, the marijuana industry, they're selling, 100 milligrams of THC products. I think the drinks, all of them have 100 milligrams. So the point is, who's selling it? I mean, according to the federal law, we can sell it, and the federal law preempts or supersedes it, or prevails in all the state law. And again, I'm no lawyer to discuss the specificities, of the law. But if the dispensaries, are selling 100 milligram, of THC in a product, there's nothing, in the law says that the hemp industry cannot do it.
And you believe that anybody in Arizona could set up a similar business to you with no license and sell?
No, we're not. We're not
THC?
saying there's no license. We're asking for regulation.
Well, right, but you have no license to sell the infused ice mochas at Wake and Bakery. So any Arizona could do the same thing, and under the same laws, the federal law that you're going by.
Well, whatever the requirements or the licenses that's required by the municipality or the state, it should be like completed and before opening. But I think we are compliant with the current regulations or requirement, to open up that kind of establishment. Sure.
I would just add to that regarding the license issue, that the Arizona legislature chose to only have a certain licenses: grower license, harvester license, transporter license, and processor license. It made an intentional decision not to require retail license. We think it should be revisited. We like the idea of retail licenses in this area, but right now the state law does not require it. And just because the Attorney General's office doesn't like that doesn't give them the power to go and enforce what they think the law should be. Rather, they should join us in the legislature to change the law in such a way where any concerns she might have are addressed. And again, I would extend that invitation to her to handle this civilly rather than to threaten these very onerous draconian measures, which certainly will involve raids, indictments, imprisonment, seizures, business closures, hefty fines, and so forth. We don't believe that's the way to go about it. If she wants to change the law, join us and we can change the law together.